I had a couple of conversations during lunch with some housing counselors who asked about this subject matter of proper ownership of the loan, and I thought I'd take a minute to repeat those questions and make a comment about it. One question was basically, should housing counselors be looking for these issues? And another point was, I've had at least one homeowner come to me with a copy of the note that they got at the closing and say, "This isn't signed, there's no signature on it. Do I have to pay the loan?" And my comment in response to the question of whether or not housing counselors should be looking for this particular issue, my answer is I don't think so, because the lawyers who do this work know that this issue is present in a majority, if not a vast majority, of all foreclosures these days, and it's much more of a legal than a counselor issue. So I wouldn't add this issue on top of all those other issues that housing counselors need to deal with. And the second issue is sort of that moral hazard issue of homeowners getting unrealistic expectations. Where does this lead? And where do I think it leads in my own cases? What I have in mind in my own cases of where I'd like them to go is just where they're supposed to be going anyway, which is towards a decent loan modification. I don't have in mind that I'm going to push this issue through a trial and get a judge to say my client never has to make a payment on this loan again. That may or may not be the implication of this issue overall, but it's not what I have in mind. I have in mind having this issue as a legitimate defense to the foreclosure in order to have some kind of leverage in this loan modification process that's supposed to be working much better than it really is. I hope to get loan modifications for my clients that not only reduce the interest rate, but do something that HAMP can't compel, which is reducing the debt to something like the value of the house for those clients of mine whose debt far exceeds the value of the house, getting rid of some of that accumulated interest and fees. But it's a fairly modest goal compared to the implications of the plaintiff doesn't properly own the loan. But it's not a radical request that I'm making in my cases. And I don't think it's an issue that the counselors need to factor in to when they're making their requests to the mortgage companies for loan modifications. It's really a legal issue that's best left to lawyers. So I wanted to take a look at a couple of other samples of problematic assignments of mortgage before I go on to talk about the case of Kemp versus Countrywide. On P75 of your materials, just as a sort of sampling of the kinds of problems that we see with assignments, the document at page 75 is a lost assignment affidavit. Couple of interesting things for you lawyers out there about lost assignment affidavits. One is that this one happens to be signed by a robo-signer. So it's not somebody who really knew anything about any effort to find the assignment, about whether or not it's really lost, or that it was just never done. I mean, that's kind of the secret. It wasn't really done. It wasn't done and lost. To me, and oh, by the way, if you flip the page, this was a foreclosure case where there was more than one assignment of mortgage, lost assignment affidavit recorded before or about the same time the foreclosure was filed. They were both executed by this GMAC employee, sort of presenting himself as the proper person to sign this kind of document for more than one company. So, who is this person who's signing these documents is one question to have in the back of your mind. How can someone be a limited signing officer, an officer for more than one company? One way in which the mortgage servicers have dealt with this sort of massive problem of documents they can't find or that never existed was to give people titles like limited signing officer, vice president of loan documentation, vice president for document signing, because a corporation needs to act through its officers. So to be a person who has the authority to transfer an interest in a property, you need to be some kind of officer. So you see rather low-level employees of the servicers, or in the case of the assignment of mortgage at P77, a lawyer for the foreclosure law firm being given titles like limited signing officer. And that they can be given that title by more than one company, apparently, so that they can sign. I know they are able to do it. Whether or not it holds up legally is the issue for us. So if you're delving into these issues in your cases as lawyers or paralegals, look who's signing these documents. Do you have multiple documents signed by the same person? Those of us who are tracking the robo-signer issue know a handful of names of people who have been identified at various servicers as people who are, quote, robo-signers. And so we start looking for those names, like Mr. Stefan for GMAC. It's hard to tell just from the signature, though, whether or not this is somebody who really knew what they were signing and had any authority to sign it, or if it was a robo-signer. And Peter is going to talk about addressing issues like that in discovery. But I think it's a fairly safe bet let me just put it this way, that who signed an assignment of mortgage or a lost assignment affidavit isn't really the big issue. The president of GMAC could have signed this assignment of mortgage, and it doesn't make it valid because, again, it's outside of the time that the trust documents identified for loans being transferred in. Having said that, I do want to spend an extra moment on the assignment at page P77, which was executed by a lawyer who works for the foreclosing law firm, which to me is just a puzzling situation where how a corporation kind of deputizes its lawyer as an officer of the corporation to sign this document that's necessary for the lawsuit that the lawyer is prosecuting. I find that very distressing. Not to mention the fact that this lawyer is now a vice president of Wells Fargo, and if I want to depose someone in the case to find out how all this takes place, I could depose this lawyer now because she's an officer of the plaintiff. This document, this assignment of mortgage on its face has the conflict between the date of the trust, the HASCO 2007 trust, and the date that the assignment was executed, being April of 2008. So again, I would consider this on its own enough of grounds to point out that there's a problem with the plaintiff's ownership of the loan. These issues have been kind of percolating in lawsuits in defense of foreclosure or in challenging claims, proofs of claims filed by the mortgage servicers in bankruptcy cases. It's been going on for a while, and every couple of months a new report, a new opinion comes out that sort of helps, from my point of view, our side. I didn't list the cases that help the other side. If Mike wants to mention those, that's up to him. But there are some pretty strong court opinions now addressing this issue. I included a list of cases in the materials. It's not a numbered page. It's the back sheet of the very first page in this section of materials. These are just a few of the more recent cases. At the point that I summarized these, they were not reported. Some of them have since been reported. But what we're going to do is post these on the plan website. So for those of you who are lawyers or paralegals at legal services organizations, you can get onto the plan website and go to the section with materials for this conference, and you'll be able to pull up these cases. The ones that aren't reported yet, I have been attaching to my motions, to my responses to summary judgment motions. So you may need to do that with some of these. I believe that Kemp versus Countrywide is going to be reported, so we should have a a Westlaw or Lexis site for it. But again, you'll be able to get these, and also some pleadings, some sample answers and responses to summary judgment motions, and discovery as Word documents from the plan website too. So in Kemp versus Countrywide was a bankruptcy case. The homeowner had filed a bankruptcy. The mortgage servicer, Bank of America, which is the successor to Countrywide Home Loans. Countrywide was purchased by Bank of America, and the Countrywide servicing arm became BAC Home Loan Servicing. So Bank of America's servicing arm services all those most of those Countrywide loans at this point. So Bank of America filed a proof of claim on behalf of the trust that purportedly owned the loan. The lawyer for the homeowner debtor filed an objection, an adversary action against the proof of claim, and one of the issues was proper ownership of the loan. Read the case opinion, because there's a lot of good detail on the strangeness in the documents that were presented by the mortgage company. There was one version of the note that had an endorsement, another version that didn't. And you can see that kind of strangeness if you push discovery in your foreclosure cases. It's possible to get different versions of the note that raise questions about, well, what's the original really look like, and when were endorsements put on the document. But the real kicker in the Kemp case was testimony by an employee of Bank of America, who had also been, I believe, an employee when the company was Countrywide Home Loans, who testified that to her knowledge, the notes, when Countrywide originated loans, the notes never left Countrywide's possession. And the court jumped on that piece of information, saying that and the trustee in the case was Bank of New York, not to be confused with Bank of America, the servicer. The judge found that because the testimony in the case was that the note never left the possession of the originator, that that Bank of New York as the trustee was not a proper party. It was actually, I'm sorry, I think it was a motion for relief from stay. I'm actually now having a moment of confusion myself about whether or not the posture was a motion for relief from stay,
I think that's right,
or the proof of claim litigation. So that the servicer on behalf of Bank of New York was asking for relief from the bankruptcy stay, and the court found that the trustee, Bank of New York, didn't have standing to get relief from the stay, because they didn't have standing to collect the debt, because they didn't have proper possession of the note. So they weren't looking at mortgages or assignments of mortgage. They were really focused on the note. So the question is, well, what if Bank of New York gets the note? And what does it mean to get the note or have the note? I mean, I picture vaults, who knows where. Mike may know more about this than I do, but vaults where these documents are stored. And is it a Countrywide vault, or a Bank of New York vault, or a Bank of America vault? Does it have to be in an office that's physically rented or owned by Bank of America or Bank of New York? I'm fuzzy on those details, but in my own cases, all I know is that they don't produce it, so that we can even talk about where it really came from. But in this case, the judge felt it was clear enough that Bank of New York didn't have possession. But what if Bank of New York comes back with possession, that the note has now been officially transferred from Countrywide's / Bank of America's vault to Bank of New York's vault? The judge in the case also looked at the most reliable version of the note and found that it had not been properly endorsed to the trustee. So it wasn't just a matter of possession of the note, it was a matter of the endorsements, the signatures indicating transfer that were a problem in that situation too. And the mortgage companies may be able to sort out the possession problem by getting physical possession into the trustee's hands. But if the notes had to be endorsed as required by the trust documents and the pooling and servicing agreements by the date that the trust closed, the closing date for the creation of the trust, then it's hard to see how you can fix that problem later on if the documents, the note wasn't properly endorsed back then. So these may not be fixable problems. And that's the end of my piece. Let's see if I had any other comments I wanted to make. So Peter Schneider is now going to address the specifics of Pennsylvania foreclosure law and how it interacts with these issues.
Well, Beth, one question. I assume if it's not fixable, then what happens? Doesn't that then mean that the servicer would probably have the right to foreclose and collect the debt rather than the trust?
I don't think, is this mic working?
I don't think.
So this was one of Mike's questions earlier, which I missed. Am I hearable in the back? Yeah. Thanks. I think there's a bigger problem than that the servicer could claim to enforce the note in its own name. But then what happens to the ownership of the loan from the trust's point of view? If that's the case with hundreds and thousands of loans, what becomes of the corpus of the trust? And in whose name is the servicer collecting the payments, and where do those payments go? I think this may end up, I mean, my hope is that we resolve this issue with really meaningful loan modifications. If we push this to its legal end, with mortgage servicers making all of their best arguments and us making all of our best arguments, I don't know where it comes out. But I think it creates huge problems for the investors who bought into these securitization trusts, these mortgage pools, as well as for the banks that are servicing them and that in some cases own big chunks of them.
I mean, the bank's fear, which goes well beyond anything that we as homeowner advocates deal with, is that it places the ownership of these loans in question, which could then require that the originating banks, to the extent they're still in business, buy them back, and they're not capitalized enough to do that, which will then put those originating banks underwater and throw the economy in far deeper trouble than it's in now. And that's not really our issue, but I think that's what the people in Washington who are looking into this are really quite frightened about.
I think that's the reason that TARP went from a mortgage bailout program to a bank bailout program, was because Washington realized that if they started bailing out mortgages, that necessarily may not have fixed the problem, and it may have just increased the problem based on moral hazard and whatnot. That at what point do you cut off assistance to homeowners in default? Or at what point do you start giving assistance to homeowners in default? The TARP was originally envisioned as $700 billion to buy up toxic assets, and then it evolved to supporting the capital requirements of banks so that the banks wouldn't fail. So, and I think that's, I think to frame this issue is you've kind of had this global perspective of banks and bank support, and all these documentation issues, the trust issues that have come up. That's great, but then how does that deal with this case that you and I are dealing with right now? And what does that mean? And I think that's what we'll be discussing as Peter goes on in a case-by-case analysis. But I think that's really the tension. I mean, I think this is I think there are fundamental changes that are on the way in terms of how banks and their lawyers process these mortgage foreclosure actions. And I think the word process is probably the first change to go. That these are legal actions. It's important to be precise and to be right, and that's a necessary change. And I think the attorney generals have seen this. Their initial review was focused on the accuracy. I think they're pretty well satisfied that the numbers are accurate for the most part. There's not wholesale losses there, but then even if the numbers are accurate, then they have now evolved more into what can we do to really get these loans back on track.
Can't figure out what to do with that door. So this gets us to what do we do as advocates for homeowners? Sam, what's our time frame here? We started a little late. How late are we going to?
Well, you started a little late because you started
Okay, just need to know how much time to go. Now, I'm going to be following the basic outline that is at pages P7 and P8 in your materials, but I've taken it off of the screen in order to be able to put some other things up on the screen. And the issue is, what does this all mean? Now you know what the problem is, but what do we do with it in our foreclosure cases? And how do we use these issues as defenses? We are going to be looking at how we use them in preliminary objections and how we use them in answers. How many people here are housing counselors versus lawyers? Housing counselors and lawyers? Okay, I hope will be understandable to the housing counselors and perhaps even to the lawyers here if I'm not completely inarticulate. But in terms of I guess first I want to lay out two ways of looking at it. The robo-signing and false documentation issues play out in a couple of ways. One question is whether the plaintiffs in filing their complaint have followed properly the requirements for a complaint for a pleading, whether procedurally they've done what needs to do for their pleading to pass to the next stage. And typically we'll deal with that either by filing preliminary objections challenging the validity of a pleading, or we may save it, strategically decide that preliminary objections are not the best way to go and file some of those defenses in an answer. The next question, beyond what is in the pleading, whether they've adequately pleaded their case enough to make it past the pleading stage, is whether they're going to be able to prove their case, whether they can in fact prove that they, as the plaintiff, are the owner of this loan, that they are the assignee of the mortgage, that they are the holder of the note. And those issues will be laid out. The defenses saying that the plaintiff has not satisfied those requirements or can't prove its case will be laid out in an answer. The rules that are going to apply to this are found in several places in the rules of civil procedure. And you'll see the list there at page P7 of your materials. The first is Rule 1019. I brought, of course, my handy-dandy rule book, so I wouldn't have to write all this stuff out. 1019 describes what has to be in a pleading. And it says, among the things that it says are that the material facts have to be stated in a concise form. So the plaintiff has to present the facts upon which its claim is based. That averments of time, place, and items of special damage shall be specifically stated, so there's a specificity requirement there. And then most significantly, under 1019I, when any claim or defense is based upon a writing, the pleader shall attach a copy of the writing or the material part thereof. And if the writing is not accessible to the pleader, then the pleader has to so state, together with the reason, and to set forth the substance in writing. So this is a requirement, since a mortgage foreclosure complaint is obviously based on at least one writing, the mortgage, that the mortgage either be attached or referred to by reference, or if it's not available, that the terms of it be stated and the reasons why the writing isn't available be explained. One question that we'll get into here is what does that require that the plaintiff attach or refer to? If it's a public document, as in a recorded mortgage, then you can refer to the mortgage by reference as a public record. But the mortgage itself is not the complete document on which the plaintiff is proceeding. The mortgage typically has this language. It will say, the borrower owes the lender the principal sum of $100,000. This debt is evidenced by borrower's note dated the same date as this security instrument, which provides for monthly payments with the full debt, if not payable earlier, due and payable on X date. That's a typical provision of a mortgage. So it's clearly referring by reference to the note. The mortgage itself does not state the interest rate of the loan. The mortgage itself does not state what the monthly payments are supposed to be. And the only way that the obligation to pay money at X percent or at X monthly payment is enforceable is because the mortgage references the note. So one question is whether that means that the note has to be attached to the complaint. It never is. I'd be curious actually to know, Mike, why it is that lenders don't attach the note to their foreclosure complaints.
Well, I think because the basis is a mortgage foreclosure, so it's based upon the mortgage. I understand your reading indicates that it should be the entire agreement of the parties, but I think the practice has always been it's based on, it's an in rem action as to the property only and only on the mortgage.
And I think that probably comes out of Rule 1147, which is the rule specifically applicable to mortgage foreclosure that provides what's required to be set forth in the complaint. And that says,
There's, in your materials at P105 is the content of that rule.
the plaintiff shall set forth in the complaint the parties to and the date of the mortgage and of any assignments, and a statement of the place of record of the mortgage and assignments, and so on and so forth. And then a specific averment of default, and then an itemized statement of the amount due and a demand for judgment for the amount due. So I would argue, and I take the position in at least my most recent pleadings, that complaint that does not attach the note does not satisfy. It may satisfy the requirements of the specific Rule 1147 applicable to mortgage foreclosures, but does not satisfy Rule 1019 regarding the content of pleadings. And I think that a complaint that only does, as almost all of them do, only attaches the mortgage is subject to being stricken through preliminary objections based on Rule 1019. Another rule that is often applicable is Rule 1024, the rule applying to verification. Which requires that every pleading containing an averment of fact shall have a verification stating the averment or that the averment is true based on the signer's personal knowledge, information, and belief. And then there's some provisions in there that require that this verification be made by a party, and then some exceptions to that. Frequently, we see complaints that are verified by the counsel for the plaintiff, and where the requirements, the reasons why one can verify by a non-party are not met. When these verifications are subject also to being stricken through preliminary objections, we might go further and question whether the people, when it's somebody purporting not to be an attorney, but somebody purporting to be an officer or an employee of the plaintiff, verifies whether, in fact, that person really is an officer of the plaintiff or whether they're an officer of something else entirely. I think typically it's the servicer's employees who prepare these things and not the plaintiffs. So that's another possible ground for preliminary objection. Another issue is Rule 2002 regarding real party and interest. I'm finding the wrong rules here. Well, it basically requires that the action be pursued by a real party in interest. And where it is being pursued either by a servicer rather than by the owner of the loan, or by somebody who claims that they're the owner of the loan but possibly isn't the owner of the loan, there's a real question as to whether it's being brought by a real party in interest. So let's look at how this plays out in a complaint. I've put on the screen here, can anybody read this? No, I can't either. Does this come out? I can't read either. I can't read this one, and I can't read that one from where I'm standing. So, oh, I know. Here it is. I've got it on paper. So the operative paragraph here, and this actually was a complaint filed by Mike's office. It's paragraph 3, where it says, on September 17th, 2004, mortgagors made, executed, and delivered a mortgage upon the property hereinafter described to Mortgage Electronic Registration Systems, Inc., acting solely as a nominee for Countrywide Home Loans, Inc., which mortgage is recorded in the Office of the Recorder of Deeds, blah, 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 blah. The mortgage has been assigned to BAC Home Loans Servicing, LP, formerly known as Countrywide Home Loans Servicing, LP, by assignment of mortgage. Plaintiff is the real party in interest pursuant to a purchase or transfer of the mortgage obligation from the last record holder, and an assignment of mortgage to plaintiff has been or will be lodged for recording. And then the mortgage is incorporated by, and assignments, quote unquote, are matters of public record and are incorporated by this by reference. So there's a lot of things in here that this paragraph says, and a lot of them are subject to attack. I guess one question is, are people familiar with MERS, the Mortgage Electronic Registration Systems, Inc.? I mean, I think any time that MERS is involved in this, you have a host of potential problems here. Here the loan was, the mortgage was supposedly made to MERS. Now, MERS is an electronic registry that is supposed to track mortgages either from the time of making through the point where they're assigned out of the MERS system, or perhaps put into the MERS system at some point along the line and then kept in the system, usually until foreclosure, when it's assigned out of MERS to the trust that purports to own it. Let's look a little bit about how to, I guess one question is as to MERS. What you're going to see there is an assignment from MERS to the plaintiff in this case. And there are a lot of questions as to whether that assignment is going to be valid or not. Some of these, now this is sort of a developing area. I just read yesterday of 2 possible attacks on MERS assignments that I wasn't even aware of yesterday. Apparently, MERS at some point in its history underwent a corporate reorganization. Let me step back a second. MERS, the people who sign for MERS, they sign as either vice presidents or limited signing officers of MERS. Now, who are these people? They are either employees of the servicer or sometimes employees of the foreclosure law firm, who say that they've been appointed as vice presidents of MERS. They do this apparently by going onto the computer and signing up as vice presidents. Now, one can question whether somebody who does that really is a vice president of MERS. I think I'm not sure what the law is in Pennsylvania as to what office you need to hold in order to take an action on behalf of the corporation, but I believe the reason that people are becoming vice presidents of MERS is because state laws require that certain actions not be taken by someone below the level of vice president. Is someone who does this really a vice president of MERS? I think it's certainly arguable that they're not. Next, apparently MERS had some kind of corporate resolution authorizing that are naming certain people, certain lists of people or categories of people as vice presidents. But then MERS apparently did a corporate reorganization, and the MERS of now is not the same as the MERS of before. But we don't know that these corporate resolutions that were made before have ever been made since. So was there even a corporate resolution of MERS that authorized these people to become vice presidents? And next, apparently the person at MERS who signs these things saying that the MERS board met and appointed all these people as corporate vice presidents is lying there, because the board never met and did this. He just signed the thing saying that the board met and did this, but there never was really a corporate resolution naming these people as vice president of MERS. So at any rate, any assignment that is made by MERS is subject to multiple levels of attack. Next issue, in this case, it says the mortgage has been assigned to BAC Home Loans Servicing, blah, 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 by assignment of mortgage. Has the assignment actually been made? Here it's incorporated by reference. It's not attached, but they say that it's a matter of public record and incorporated by reference. Well, if it hasn't been made a matter of public record, then it has to be attached. You can't get around that requirement by referring to a public record that doesn't exist. So I think if I can move to the next slide, we can see how this plays out in an answer. Of course, you can't read it, can you? I'm sorry that these aren't in the printed materials that you have. It's a fairly convoluted paragraph. It sort of has to be, unfortunately, because the paragraph that it's responding to had so many different averments in it as to who the mortgage is made to, who the plaintiff is, who the assignees are, and so on and so forth. But basically what you're seeing here is that the averments are being denied. We're saying that we don't have knowledge or information sufficient to know whether or not the assignment was made as is alleged, and strict proof is going to be demanded. Now, what this sets up, and we'll have to talk about it a little bit later in the session, is the need to do discovery, where you're saying that you're denying something on information and belief. You do have an obligation then to try to get to the facts that underlie that denial and try to get the information that is going to show whether your denial is correct or not. I think you can't fairly plead these things in an answer and then just wait and do nothing. You need to do some discovery. Now, lenders may have been a little bit encouraged by a Superior Court decision called Mallory, in which the homeowners attempted to open or strike a judgment against a homeowner, claiming that with a averment sort of similar to the one in paragraph on the previous screen, that the complaint was defective because it didn't properly it didn't meet the rules of pleading as to the assignment of the mortgage, and the Superior Court unfortunately came down with a bad but a fairly limited decision, striking down those
I
preliminary
thought it was a
objections.
good opinion, actually, Peter.
Of course you would.
It's one of our few wins in the last couple of years. Give me something.
But Mallory was a fairly unusual case in that it was brought as a petition to open or strike. The judgment wasn't opened because the petition was filed way too late to open it. And because the judgment wasn't open, it meant that the allegations that were pleaded were essentially deemed admitted. And all that Mallory really stands for is that where the plaintiff pleads that that it's the owner of the loan, that you may not be able to strike that down on preliminary objections.
So what you see is that for the unrecorded assignment, the best practice is to have it lodged for recording, actually record it, and to cite the recording information. Our firm will either do that or attach a copy of the to-be-recorded assignment as an exhibit to the complaint.
And that apparently passed muster in Mallory. On the other hand, that doesn't mean that the assignments that plaintiff is presenting are valid assignments, and you can still attack by preliminary objections the validity of those assignments. You're not saying that the pleading requirement isn't met, but that there is no jurisdiction or there's no standing on the part of the plaintiff because the documents are invalid. That raises a somewhat difficult procedural issue, at least in Philadelphia. I don't know, I know practice is very different everywhere in the state. In Philadelphia, it's not very easy to deal with preliminary objections that raise disputed issues of fact. The court doesn't seem to be well equipped to adjudicate them. And in situations like that, we've pretty much come down to the conclusion that it's better to raise those by way of answer rather than preliminary objections and fight out whether the facts are true or not in the context of litigating the case rather than as a preliminary matter. But it would be perfectly appropriate to raise them as preliminary objections. I think that the rule regarding preliminary objections says that in cases of disputed fact, they'll be decided on depositions or otherwise. There's something fairly vague out there. Do people here have experience with in other counties with litigating preliminary issues of fact that are raised by preliminary objections? So maybe your experience is similar to ours.
Well, and of course, the plaintiff has the absolute right to amend its complaint, and in some cases can cure, especially things like attaching the recorded assignment or other things that can be easily cured, can be done through an the filing of an amended complaint and service on the attorney and parties.
But sometimes the issues get bigger, and you'll see here, we can move here to where the way some of the issues are raised. This was in the context of an answer, where we're asserting here that, find my page here. The plaintiff is not a real party in interest on information and belief that the mortgage assignment attached to the complaint and the recorded mortgage assignment to plaintiff is not valid. On information and belief, MERS did not have the authority or ability to validly assign the mortgage to plaintiff at the time of the purported assignment. On information and belief, neither MERS nor Countrywide held or owned rights to the note obligation underlying the mortgage at the time of the purported assignment. On information and belief, Countrywide did not hold the mortgage at the time of the purported assignment. On information and belief, the signatories to the purported assignment did not have the authority or ability to execute a valid assignment on behalf of the purported assignor or on behalf of the then holder or owner of the mortgage. So you're raising, it sort of sounds like a lot of mumbo jumbo, but in fact, you're raising serious questions as to the validity of the documents that are attached. You're not saying here that the documents themselves weren't attached, but you're questioning their underlying validity. Plaintiff lacks standing, and we're sort of reasserting the same factual issues as a challenge to standing. And here we're claiming that the entire action is illegal because in this case, it's the issue that I raised before. The issue of the complaint in this case was filed in the name of the server. We don't believe that by the servicer. We don't believe that the servicer really owns this loan as they claim to, and that they really are filing as an agent for the owner of the loan, and that violates Pennsylvania's criminal law, which does not allow a debt collector to file actions in its own name. On this screen, we've got preliminary objections that raise similar issues in the context of POs. Failure to attach a written assignment. In this case, this is a different case. There was no written assignment actually attached. This is actually one of the cases that you have some of the assignment issues in your materials that underlay these preliminary objections. This was a case involving the robo-signer Jeffrey Steffen, but this was filed a couple of years ago before all the information about him became quite as public. But in this case, Steffen claimed to be an officer of one company and signed an assignment from that company to Company B, and then a couple days later he claimed that he was an officer of Company B and assigned the loan to Company C. And that looked awfully fishy, and we raised that in the context of these preliminary rejections, saying that the documents weren't valid. And it's styled as failure to comply with the rule of court, failure to prosecute an action by real party in interest, lack of standing, lack of subject matter jurisdiction. So as you can see, these can be raised in both contexts, either as an answer or as a preliminary objection, and I think it's often a matter really of strategy to decide which way you want to do it. This is a Pittsburgh case where Eileen, in a much cleaner way. I think what we'll do is we'll copy these onto, we'll get these put on Plan's website so that you can actually look at these. Eileen managed to distill some of these issues and draft them in ways that are perhaps a little bit less convoluted. But she's really raising the same issues. Plaintiff is not a real party in interest. Upon information and belief, MERS did not possess any legal authority or capacity to assign the mortgage to plaintiff at the time of the purported assignment. Upon information and belief, the purported assignment attached to the complaint is not valid, and so on and so forth. There were other issues in this case that had to do with the plaintiff's failure to properly process the loan for modification under HAMP. That's really not the subject of what I'm talking about today, and it will be the subject of a later presentation. So I don't want to get into it in detail at this time, but I know that Rachel and Aisha will. This was another answer where similar issues were raised, and this case actually brings out some of the serious issues here. There's a case that I'm litigating now where this mortgage was actually assigned to two different trusts. First, it was held by one company that bought it as a bad debt at some point. They assigned it to trust number one, and that trust number one at some point, for some reason, assigned it back to them. But in the meantime, they had assigned it out to somebody else. Or to MERS, and then MERS then assigned it to the plaintiff in this case. So you have a situation where the chain of assignment that the plaintiff is relying on is essentially defective back to the beginning, because this chain began at a point where the mortgage had already been assigned to somebody else entirely. And there's serious questions there. If our client were to pay off the mortgage to trust number two, and trust number one then came along and said, hey, we own the loan, you owe this money to us, be hard to come up with a defense to that. So we challenged that, again, in an answer. This case is going to play out in some way. I think it may involve Mike's office also. I'm not sure. I didn't know that Mike was going to be here when I picked this.
Now I know why the door's open behind me.
Mm-hmm. But I think it's useful when you are challenging the validity of these assignments to say as much as you can, to put as much factual information as you can about the basis for your dispute, so it doesn't just look like boilerplate, meaningless stuff. And in this case, starting here at paragraph 38, which of course you can't read, we tell the story of what happened to this assignment and why it's not valid. I think it's, especially if this is going to come up in the context of summary judgment, where you're going to need to defend against summary judgment, you want to have a vermince in there that makes sense and provide the necessary facts. We have 3 minutes to talk about discovery. So I will point you simply to page 99 or page P109 in your materials, where you have some sample interrogatories and document requests involving these issues. Now, I'm not going to pretend that these things are the most artistically done requests. This is a developing field. Like I say, every day you read new things. You read things that you wish you had done the last time around. But this discovery ought to give you a start at ways to try to get the information from the other side that will indicate who really does own this loan, and on what basis are these people, is the plaintiff claiming that they own this loan. A couple of other things that I'd add to that, things I didn't know about at the time that I prepared this discovery. Apparently, MERS maintains something called a milestones report. Do you know about that, Mike? MERS milestones?
No.
It's apparently some kind of an online system where MERS keeps track of what its members say about the ownership of a particular loan. So if you're an assignee of this loan and you want to write in to say that it's been assigned to you, you go online to MERS and you fill out the entries, and it gets reflected on a MERS milestones report. This will, if you can get a hold of this, will indicate at least something about the actual ownership of this loan, although it's not necessarily accurate because it's based on whether or not the various players actually did enter the information into the milestones report, and apparently they can go back and fix stuff that was wrong. So you never know whether it's really going to be true or not, but it's going to at least give you some information.
Peter, I was hoping we could give Mike a couple of minutes at the end
To answer to
kind
all of this, yeah.
Well, and also, he made some comments about where he thinks the practice of foreclosure law from the plaintiff's side is going, but I'm wondering if he also has some thoughts about where dealing with the servicers on loan modifications, and since we have counselors in the room for whom
Okay.
that's a day-to-day reality.
Well, let me just add one thing, and then I'll turn it over to Mike. Another thing that you may be looking for is whether there were FedEx receipts or other receipts that were given at the time that a note was in fact transferred from one entity to another. And that's another specific thing to ask for that's not in the materials here, but may be worth your time. So I will turn it over to Mike. Thank you.
All right. Thanks, Peter. And thank you, Beth. And thank you for inviting me today. I do think that the idea of, and Beth touched on this, and Peter has discussed it as well, about unrealistic expectations and, what's the outcome for that individual borrower? As I said earlier, we have kind of these global issues that oversee everything, but, how do you help the homeowner that's sitting before you? And, we've talked about the situation that if there's a defect in the pleadings in some way, perhaps the easiest answer for the lender is dismiss that pleading, get its house in order, and refile it. That could be a 6 or 8 or 10 month process, and it sounds really good, but then by the time it comes back to your desk, that homeowner is now 2 years in default, and probably has struggled for the last year in trying to get somebody at the bank to pay attention to what's going on. I would like to think that because of our involvement in a case, that we can use our connections at the bank to make sure that loan modifications and workouts are properly addressed. I would suggest to you that now is probably the best time ever to settle mortgage foreclosure actions in favor of your clients. I think that there's a tremendous amount of ability to do so from both housing counselors and lawyers. I suspect that the attorney generals will come out with some sort of with settlement agreements with various of the lenders that address the robo-signing issue in terms of some sort of monetary credit towards homeowners who take advantage of that. That's at least been discussed. I'm just based on press reports, nothing that I have inside there. But I think that that's going to be an element because their focus seems, again, to have shifted more towards, if the modifications were done, and I think the modifications are going to necessarily have to include principal reductions now. I think whether it's out of the bank's own pockets or the investors, it's inevitable. That's really where the industry needs to be, along with all the other things that they need to get to. And there are a tremendous number of issues here presented, and it is incumbent upon this to be done with with attention to detail, with precision, and yes, even perfection. But once that is done, and the banks and lenders and law firms get their houses in order, what then can we see on the borrower side? I still think it's incumbent to look at all the solutions for borrowers, that whether it's loan modifications, HEMAP. By the way, every time a homeowner calls, the first question I ask them is, have you applied for HEMAP? And of course, those homeowners are in default. So I'm a big proponent of HEMAP and its progeny. I think the conciliation programs have been successful in those counties that have done it. Whether they're mandatory or voluntary, I think they offer a lot of value to get homeowners to get to court and get the process running on that. And I think, generally foreclosures are put on hold while that modification process is being reviewed. So that could be a win for the homeowner. And I really think those are the programs that we need to pay attention to as well. What it can be done to take this from a very, somewhat abstract area to something very real for that homeowner. And I'd rather be talking about loan resolution than responding to discovery request and spending money and time and effort on that. Not that that's not important, and I understand that, and I understand the importance of it, of the details. But I think in the end, the practical result for that homeowner is as important as well. So that's all I had. Thank you.
Thanks, Mike. I would actually like to specifically thank Mike for coming here. Most of us are on one side and Mike is on the other, but he's a very decent guy to work with, and we appreciate his being here.
Thank you. Thank you.